Good morning, everyone.
Good morning.
Thank you. Justice Strategies and I want to thank Congresswoman Eddie Bernice Johnson and her staff, in particular Carrie Palmer, for hosting this timely panel. Justice Strategies is honored to facilitate this Hill briefing, and we thank today's moderator, Nikichi, and our panel members, Glenn, Pam, Dalton, and Liz, for taking the time and sharing their expertise with us. In the next 5 minutes, I propose to you an opportunity for improvement. So there are pieces of our research that point in the direction for this, and we hope that Congress and the U.S. Sentencing Commission will take a look at what we're proposing. Opportunities for improvement, alternatives to incarceration, and family impact statements. The most direct way to reduce the cost of parental incarceration, in which my colleagues will flesh out in greater and poignant detail, is to promote alternatives to incarceration. First step. At the pre-sentencing hearing of an individual convicted of a non-violent drug offense or a drug-related offense, the court would be required to ask whether the person is a parent. Step 2. If the individual is a parent, the court would be required to hear and consider the impact of incarcerating a parent and what that impact will be on the children. And this could be done through a family impact statement or family responsibility statement. I'll leave it to my colleague Liz to elaborate a lot more on that, as Osborne has been leading the way in looking at family impact, family responsibility statements. Third step, after assessing all the facts before him or her, the federal sentencing judge should be encouraged to exercise sound and judicial discretion with respect to sentencing a parent to an alternative to prison, i.e. probation, education or job training programs, housing support, health, social, and psychotherapeutic supports, medical support, including methadone treatment, and drug treatment programs. What I just described is based on a compilation of our research within the United States and internationally. Let's turn to the U.S. A 2003 U.S. Sentencing Commission report surveying judges on federal sentencing guidelines found, and I quote, both district and circuit court judges reported the desire for more emphasis to be placed on pertinent offender characteristics. More than half of all judges would like to see more emphasis on sentencing placed on an offender's family ties and responsibilities. The report further found that, I quote, the vast majority of the responding judges were positive about the availability of alternatives to incarceration and did not want to see the availability reduced. Before the 2005 Supreme Court decision in United States v. Booker, federal judges have tried to hear and minimize the detrimental impact of parental incarceration on the innocent lives of children, but they were often overturned on appeal. Here's just one example of many. United States v. Chestnut, and I quote, status as a single mother of 3, now 4, young children simply is not, as the defendant contends, is not an unusual family circumstance to allow for downward departure from U.S. sentencing guidelines. Pre-Booker, judges' discretion was limited by the guidelines, where it was deemed that the family, and I quote from the guidelines, family ties and responsibilities are not ordinarily relevant in determining whether a departure may be warranted. The Booker decision has now made the guidelines more advisory, but the many years following the guidelines and being overruled on appeal may have affected judicial discretion now. The second report by the U.S. Sentencing Commission, published in 2012, explored the continuing impact that U.S. v. Booker has on federal sentencing. The Commission found that, and I quote, "Current law, as interpreted by the Supreme Court, directs courts to consider broadly offender characteristics, and judges increasingly sentence offenders outside the range based on the characteristics that not only fail to distinguish the case from the norm, but, to the contrary, often present the typical case." The Commission goes on to state, "Both historical underpinnings of the Sentencing Reform Act and current law demonstrates that judges weigh factors differently and have widely divergent views about the relevance of offender characteristics at sentencing. To the extent the interaction between the Sentencing Reform Act's directives to the Commission and its instructions to judges is unclear, as currently is the case, unwarranted disparity becomes inevitable." Now let me just turn briefly to the international law, because there is something that we can learn from Commonwealth nations. In Australia, federal judges are mandated to hear and consider the impact of parental incarceration on children and are afforded discretion with respect to sentencing a parent. In some cases, judges shorten the sentence or offer an alternative to incarceration. In closing, as you listen to my colleagues and read over Justice Strategy's latest report, Children on the Outside 2014, An Agenda for Change, compiling the newest and groundbreaking academic research on intergenerational impact of mass incarceration, we invite you to consider the significant costs to children and their communities presented by parental incarceration. And we recommend that policymakers and the public seriously consider measures to reduce the number of parents sentenced to prison in the first place. Thank you.